I want to talk a little bit about disclosure of documents, and I'll say more about disclosure of documents in a future talk. But Rule 31 deals with disclosure of documents. The rule is that the Employment Tribunal can order any person in Great Britain to disclose documents or information to a party by providing copies or otherwise, or they can allow a party to inspect that kind of material. And these types of material are the types that could be ordered by a county court, or in Scotland by a sheriff. So note that the rules allow for disclosure of information, so it doesn't have to be a tangible document. Secondly, note that it's such disclosure as might be ordered by a county court, or in Scotland by a sheriff. The principles of Rule 31 of the Civil Procedure Rules, these are the rules that govern the High Court and County Court and the Sheriff in Scotland, deals with disclosure in that context. Now, Rule 31 states that disclosure means stating that a document exists or has existed. That's Rule 31(2). Disclosure of the item has to be necessary for the fair disposal of the case and openness. And in the civil courts, a process of what's known as standard disclosure has arisen. Standard disclosure requires parties to disclose only those documents which are or have been in their control and which satisfy the following criteria. So they're going to be information or a document on which the party relies, or which adversely affects or supports either their own case or another party's case, or which they're required to disclose by a practice direction. The CPR, that's the Civil Procedure Rules, 31(6) and 31(8) deal with this. What the Civil Procedure Rules require is a reasonable search for those first two types of document. Increasingly, however, you're going to have to be able to make representations about electronic documents, and there is quite a complicated process in the High Court and in the County Court for electronic disclosure. This has to deal with the large amounts of information that the disclosure of material on an electronic database might disclose. So in a later talk I'll deal with electronic disclosure. The other point to notice about disclosure of documents is that the duty continues to the end of the proceedings. Each party must notify the other if relevant documents come to their attention before the end of the process. And this is why you may find yourself receiving documents from a lawyer on the other side who, in accordance with their duty to make disclosure, which is a continuing one, produces a document to you, and it may be a document that helps your case or hinders it, and equally it may be a document that helps or hinders their own case. But that's what's going on when they produce those documents. The rule is that you should notify the other side really as soon as relevant documents come to your attention before the end of the process. Now, something else that very often worries litigants, and particularly employers, is the use that the other side can make of the documents that have been disclosed. It's very important to know that unless a document has been read to or by the court at a public hearing, or the court or tribunal gives permission, or the discloser and the owner of the document agree otherwise, then the party to whom disclosure is made can only use the document for the purposes of the proceeding in which it's been disclosed. Moreover, the court can order further restrictions on the use of the documents. They can make orders restricting or prohibiting further use of the document. That's CPR 31(22)(2). Well, as I say, I'm going to leave that topic there because we'll talk about disclosure in a future talk.